Just by way of a brief introduction, my name is William. I'm a qualified solicitor and also a qualified civil engineer, and so very much a technical person by training who now does the law and uses that technical knowledge to unlock legal problems. So in terms of what we're covering over the next 60 minutes or so, this, as I say, is session 1, and we're covering the basics. You know, what I've described this as is a crash course in construction law, or contract law, I should say. Starting with the genesis of a contract, how the contracts are born, how they are formed, to be more precise, through to how they die at the end, how they are terminated and discharged, and everything in between. We're going to be looking at ultimately what you need to form a contract, that offer and the acceptance, coupled with intention to create a contract, which is a vital component, and also consideration, that exchange of something of value. Again, all three of those things, agreement, intention, and consideration, are needed to form a valid contract. We'll look at some examples of how they form. You know, I'm going to try to give this as much of a construction spin as possible, but do be mindful from the outset that the law that we are looking at here is not necessarily construction specific. The law of contract applies more broadly than construction. It applies to most other industries and commercial industries at that. What happens if you break a contract? What happens if you breach it? What are you entitled to? Most people will have heard that term damages. We're going to do a little bit of an investigation to explain what exactly damages are and what the measure of calculating damages is. And then finally, as we say, through to the death of the contract, through to termination and discharge, and the various different ways in which a contract can be terminated or can be discharged. We'll look at all of those in a bit of detail. So the way I like to explain contract law is by reference to this diagram. So the first thing you need to bear in mind here, this session, which is taking place over 60 minutes or so, is going to be very, very shallow. We cannot get into the full level of detail on all of these topics, because the law of contract is a broad church. This area of law will be studied by a law student for a full university semester, if not 2, just to put it in context as to what we're looking at today. But with that in mind, it breaks down to something like we see on the screen here. There's always step 1, which is how do contracts form? And from a helicopter view, there are 3 different things that you need to have a legally enforceable contract. You need an agreement, which is made up of the subtopics of offer and acceptance. Dear William, I will buy your iPhone off of you for £100. That's an offer. It's clear, it's certain, it's got that intention to be binding behind it. And then it's me accepting that offer on the other side of the coin. Those 2 things are required, and those are what we call the agreement. The second thing is intention to create a contract. And there's a couple of different scenarios that we'll look at there, be that in a business context, where there's always deemed to be that intention, or at least it's a rebuttable presumption that there is, or into a domestic scenario between housemates, or between a husband and a wife, or between friends, where, as you can imagine, things that you say on a poker night or when you're down at the pub, they might not have that same intention behind them for obvious reasons. And then lastly, a rather peculiar facet of English law is the requirement to exchange something of value, and that is what we call consideration. The law in that area is slightly complicated. Even the word itself doesn't really lend itself to understanding what that means, but for broad brush purposes, it means giving over something of value. So if you're selling your iPhone, it's the £100 that you get in return for that. The promise is to give the iPhone, and something has to be given in return for that promise, in consideration of the promise. That's where the word comes from. So once you get into contract, you then move on to looking at their contents. Now, this is not something we're going to cover today in very much detail at all. We're going to look at that more in the next session with a construction industry focus, looking at some of the common express terms in the UK and Irish construction industries, looking at some of the implied terms, particularly if you're in the UK under the Housing Grants, Construction and Regeneration Act, which gives rights to dispute resolution and certain payment terms, and the equivalent in Ireland we will look at as well, which is the Construction Contracts Act of 2013. So again, once you moved on and you understand the contents, we're then going to be looking at what happens if those contents are breached. What happens if you don't do what you signed up to do? That's a breach. It's no more complicated than that. And then what is the remedy for that breach of contract? Again, it depends on the type of breach, it depends how severe it is, and it ultimately depends very much on the facts and the circumstances surrounding it. So we'll look at some of those remedies and the legal tests that we have to come up with those. And then finally, how to bring the contract to an end. As I say, that is what we call discharge of a contract. And there's a number of different ways that you can do that. Some are more contentious than others, but again, we'll look at those in a bit of detail and explain how and when disputes arising out of the discharge of a contract. So just looking, before we get on at a couple of questions here, I'm going to try to keep an eye on the question screen just as we go along. Feel free to ask any questions as we go along. There's a question there from Joe Kelly. How does a letter of intent fit into contract formation? What's the legal binding effect in relation to the formation of a contract? It very much depends, Joe, on the wording of the letter of intent itself. That wording could be worded as a standalone contract. It could have all of the operative terms that you need, how much you're going to be paid. It might be worded in such a way that you get paid up to a maximum amount. It might then incorporate some terms from the main contract by reference. It very much depends on the wording of that letter of intent, Joe, but it probably would be treated as a contract in its own right. There's another question there from Marta. Will the contents of this presentation be applicable to Scottish law? Broadly speaking, yes, but there are a few subtle differences when it comes to Scots law. One prime example for the purposes of today is the need for consideration. In England and Wales and in Ireland, it's a requirement to have consideration as part of contract formation. In Scotland, it's not. It's slightly different there. So if you are working in Scotland, you do need to take this content with a pinch of salt. Good. So first question that we have asked ourselves is, what is a contract? For a contract law presentation, probably a good starting point. So it's no more complicated than this. A contract is a legally enforceable agreement. If you signed up to a contract or you have entered into a contract, because signature is not strictly speaking required, then it will be enforceable. If one party neglects to perform their side of the bargain, if they don't hold up their promise, then you can sue them in the civil courts as a result of that. So again, it's a fairly important thing to understand that it is simply a legally enforceable agreement or promise. The question then becomes, well, that's fair enough, but what makes the agreement enforceable? And what makes the agreement enforceable are the three ingredients that I briefly touched on the previous slide, and I will go into in more detail shortly. The requirement to have an agreement, an offer, and an acceptance in response to that offer. That's what we call the agreement. To have that agreement in the presence of intention and consideration as well. If you have all of those ingredients in place, there's a few more that we could go into, but these are, the basic requirements. Then you have that legally enforceable agreement. And if one side fails to perform their side of the bargain, you can sue them on the foot of it. The next question then is, why are contracts so important? Why does this area of law exist? Well, it's quite important for one very simple reason. It's the backbone of our economy. The commercial sector, construction, hospitality, all of those other industries rely upon contracts day and daily. Think of what the world would be like if one party could make a promise and there were no repercussions of keeping that promise. You can imagine that you would never have any certainty over anything. Imagine if you had taken a loan off the bank to purchase your house and all of a sudden they've hiked up the interest rates without agreement, or they've decided to send someone in to repossess your home. Again, you can imagine a world without contracts. It would not be a very nice world to live in. So that's why contracts are so important. The final preliminary point I always like to make when giving people an introduction to this area of law is the fact that contracts do not need to be in writing, nor do they need to be signed. People, I think, have this misconception that you need to sign on the dotted line for your agreement to be binding, or that there's some sort of extra emphasis is given to an agreement if it's signed. Well, that is not the case. All you need is agreement, intention, and consideration. There's no extra formality step there to have it signed or in writing. So you could be talking over the phone to a subcontractor, and you could potentially enter into an agreement on the foot of that phone call. And again, that does happen from time to time. So with that preliminary point in mind, always bear in mind that the law that we are looking at here could potentially apply to oral contracts as well, not only written contracts. So this is our first piece of headway into a item of case law, and it is the case of Smith and Hughes, and it's very often the starting point when people start to look at the law of contract. What this case sets out is how the courts will interpret a contractual agreement. And I'll say that again. This case sets out how the courts, in other words, how you should be doing as well, should interpret a contractual agreement. It has got nothing to do with what the two parties subjectively thought they were agreeing to. If I thought I was getting the best deal in the world, that does not matter. What matters is the objective intention. To the reasonable person looking at these parties entering into this contract, what would that reasonable person have thought they meant? The courts, nor anybody else, can physically put themselves into the minds of the parties. It's not like the Matrix where we can plug into their minds to understand what they actually intended by their words or conduct. So therefore, the only thing the courts can do is look at it reasonably. What would the reasonable person, knowing all of the facts, understanding these parties, what would they think the agreement between them was? And it is that objective approach that the courts will use when interpreting contracts that are not in writing, and to an extent contracts in writing as well. Because take it from me as a construction solicitor that deals with disputes day and daily, you might think you know what you're writing down, but whenever you actually step back and ask someone else to read it, it could mean an entirely different thing. So it's that objective approach the courts will use when interpreting contracts. So, mindful of those preliminary points, what a contract is and how the courts will interpret them, we're now about to open up and explore contract formation. So we're on the first line of this diagram, and we're going to be covering all three of these items: agreement, then on to intention, then on to consideration. You need all of these things to have a contract validly formed, and you need all of these things for the agreement to be legally binding. So the first question we have to ask ourselves, what is an agreement? Well, as you saw on the previous slide, the agreement aspect is made up of two parts. There is the offer. I want to buy your iPhone for £100. I am offering to buy it for that amount. Again, the proof is in the pudding there. And then on the flip side of that coin is the offeree responding to that offer and actually accepting it. If someone was to turn around and say, I'm not going to take the 100, I want 120. Does that sound like acceptance to you? The answer should be no, it's not an acceptance. That's actually what we call a counter offer. For an acceptance to be valid, it has to perfectly match the terms of the original offer. I will buy the iPhone off of you for £100. I will accept that amount of money and the iPhone is yours. It matches the terms of the original offer perfectly. If you go and you try to change the purchase price, it doesn't quite match up and there would be no valid agreement there and therefore no contract. Where that comes into play is when you're negotiating with the likes of subcontractors. So you're asking them for their best price. We can do it for £100,000. The main contractor might turn around and say, you know what, we've only got 80,000 in the kitty here, take it or leave it. There's no contract formed at that point because the original offer of 100,000 is offer one. That was destroyed by a second offer of 80,000, that counter offer. No acceptance, no contract. So what this dotted line represents is the other things that have to be in place that surround this agreement. And those are ICLR, which is shorthand for intention to create legal relations. In other words, you have to have intention, and also consideration. You need all of the items on this screen to validly form a contract. If one of them is missing, the contract falls down and it would not be enforceable. So we're now going to break down that agreement into looking at the offer on one side of the fence and the agreement on the other side of the fence. Looking at offer first of all. If I was going into a lot of detail on this, like I do with my students at Queen's University, we'd be looking at these two cases to define what exactly an offer is. And for the purposes of your notes, those are the cases of Storer and Gibson City Council. Sorry, Storer and Manchester City Council, and Gibson and Manchester City Council. Two cases against Manchester City Council with two very different outcomes. These decisions ultimately between them set out what amounts to a valid offer and what doesn't. And the thing that you have to take away from those particular cases is that for an offer to be binding, it has to be clear and certain and has to be made with the correct intent. If the offer is uncertain, if it's unclear how much exactly you're offering for the iPhone, or if someone has multiple iPhones and you've made an ambiguous statement and you don't know which one you're actually after, it would feel for want of certainty. Or if it was your little brother trying to buy an iPhone off of you, it might feel for lack of intent because, again, he's your younger brother. You weren't actually going to take the money off of him. So again, those two cases, when you contrast them together, give a very good definition of what amounts to an offer. Where things get slightly more complicated then is when we get into this area, looking at what we call invitations to treat. An invitation to treat is not an offer. That's the key thing to take away here. An invitation to treat is the expression of willingness to receive an offer. For example, you go to the auto trader and you see some car that you're after that you want to purchase. The advert for that car in the auto trader is not an offer. You can't ring it up. You can't ring up the auto trader and accept the offer that you're reading in their magazine. The image in the magazine itself is actually an invitation to treat. That is the auto trader telling the world that they want people to make them an offer for the car, and it would then be up to the auto trader or the owner of the vehicle to accept it. I'm going to look at that with reference to a very popular piece of case law, but that's just to give you a bit of an idea from the outset what we mean by that term, invitation to treat. And then the final sort of subtopic here from this perspective slide is different ways in which you can terminate an offer. We're not going to get into that today, but at the end of the day, you make an offer verbally, you can retract it verbally. There's certain rules that go in and around how that communication must be made. There's different ways to terminate an offer. It can terminate by passage of time, it can be terminated by express revocation, it can be terminated by third parties in certain circumstances, but we're not going to be looking at that for the purposes of today. But just know, if you have made an offer to purchase something, you can retract that offer. It doesn't have to sit out there forever. You can withdraw it. So going in then to a bit more detail on what exactly it means to make an offer. So the first thing I would say about this is forget everything you know about the term offer. You know, when you see something in the paper being on offer for 50% off, it's not an offer, okay? You cannot ring up the paper and accept it, okay? If you see something in the paper, it is only going to be that expression of willingness to receive an offer, that invitation to treat. So the first thing I always recommend to people is to forget everything you know about the word offer, giving it its plain English meaning. We're looking at it in terms of its legal meaning here, which is slightly more important. So this is what we mean by that legal meaning of the term offer. It's an expression of willingness to contract on certain terms. I want to buy your iPhone, that particular iPhone, for £100. It's very clear and it's very certain. And if you're making that offer, if you're making that statement across the shop counter in the CEX store or the secondhand mobile store, clearly there's an intention there to form a contract with that commercial entity. The case might be different if you're making the same statement to your wife or the same statement to your husband. because that's in a domestic context. But the two main takeaways here is that an offer, that statement of your expression of willingness to contract, must be clear and certain, and it must be made with the requisite intention to contract. So that's what it all boils down to. There's a lot of law that goes behind this, but I'm trying to keep this at a fairly high level for the purposes of today. So what we've just described there, this very clear, very certain offer, which if you accept it will become binding, can be distinguished from this other term that we've already briefly mentioned. And that is what we call an invitation to treat. It is a terrible term. I don't know why they decided to go down the route of calling it that, but it's simply someone asking for offers. That's what it is. It's an invitation to provide me with an offer. And we're going to look at some case law to illustrate what exactly I mean by that. So in terms of what that term means for the purposes of defining it, an invitation to treat is an expression of willingness to receive offers. Think of the auto trader. Think of opening up that book and it effectively being an open invite for you to ring up and offer the best price. That's exactly what an invitation to treat is. The key point is that you can't accept an invitation to treat for obvious reasons. There only is one car available. So what happens if 15 different people ring up and try to accept the advert in the paper? It just wouldn't work. You couldn't have 15 different contracts because there only is one product, which is why in the eyes of the law, that advert is only treated as an invitation to treat. So there's a number of recognized examples of what amounts to an invitation to treat. I've been talking about one of them in a bit of detail, perhaps two adverts, brochures, you might want to call them one and the same, because that is by far and away the most obvious, but there are more. You walk into Tesco's, for example, and you see something sitting on the shelf. Can you enter into a contract by simply picking it up? And that's the question that came before the courts in a fairly famous case of the Pharmaceutical Society of Great Britain versus Boots, Cash Chemist. Again, I'll let you look up that case if you're interested. And in the UK, the answer to that question is no. The contract does not form when you take the item off the shelf. It's not an offer being on the shelf. The offer is not made until you get to the checkout, where the customer offers to buy the goods and the cashier accepts it and they accept the money. That's where the contract comes into play at the likes of Tesco's. Same thing applies in shop windows. If you go into a shop and you see a really nice bicycle that you would like to purchase, you can't just walk up and pick it off in the shop window and accept that offer because it's not an offer. It's only an invitation to treat. The contract doesn't form in that scenario until you, the customer, goes to the cashier with the bicycle, offer to buy it for the sale price, most likely, or perhaps with a discount, and then they accept that price. Offer, acceptance, contract accepted, contract entered into at that point. Tenderers or tenders, again, same thing applies, which again is important in construction. This one is often called an invitation to tender. In other words, an invitation to provide an offer. The public sector body that is going out to tender, they are effectively telling the world that they want to enter into contract with someone. Everyone provide me with your offers. 5, 6, 7 different people might provide a tender. That tender is the offer, and then it is up to the public body to accept the one that they want to accept, which would probably be subject to the rules that they set out in the tender itself. So again, multiple offers, one acceptance, one contract. We've got a quick question here from Ronan Fitzmaurice. How do you prove the formation of a contract over the phone and avoid a he said, she said scenario? You can't avoid that, Ronan. It's ultimately down to the party that's asserting that there is a contract to prove it. The court ultimately has to weigh up which evidence they prefer there. Is it more likely than not that a contract formed is the test that the courts would apply? We call that the test of the balance of probabilities, but it can be extremely difficult, Ronan, and it probably would be a case of he said, she said. And in that scenario, the party trying to prove that the contract existed might not be able to do so and therefore they would have to bear the repercussions of that. So it can be very difficult to do, Ronan. Good. So going to go into this particular recognized example in a bit of detail, to show you why exactly an advert or a brochure amounts to an invitation to treat and not to an offer. We go into this one because there's a fairly famous couple of cases in this area that most people that study contract law will always remember. So again, you can go and have conversations with those people if you'd be that way inclined. So the general rule is that anything that you see in an advert, anything that you see in a brochure or a price list is not an offer. You can't ring it up and accept it. It is only an invitation to treat, that expression of willingness, as we said earlier, to receive an offer. The first case that we have for that is Partridge and Crittenden. It's a case to do with the sale of live birds, which back in the 50s and 60s and 70s was illegal in the UK. You cannot offer for sale live birds. It's a criminal offence. And the defendant in this case was ultimately convicted, but he appealed it. He appealed it on the grounds that the very fact that he put the offer in the paper shows that it was not an offer. It was merely an invitation to treat, because the offer would come from the customer that wants to purchase the bird from the person putting it in the paper. It's a very, very tight distinction, but it is an important one at that. Anything that you see in an advertisement is not an offer. It is an invitation to treat. That's the general rule anyway. It's a little bit more complicated than that, as we will soon see. So let's break down that analysis. And the analysis that we're about to go through here, this is exactly what a court would do when initially trying to determine if a contract has come into play here, if a contract has actually formed. They will go through all of the facts. They will identify where the offers were made, where any acceptances were purportedly made, and they will determine where and on whose terms the contract was formed. So here, the advert for the sale of the birds was an invitation to treat. The offer is when the person responds to the advert and thereby makes an offer. So I can see in the paper, you're selling some birds. I would like to buy a bird for that price. That is the offer. That's that key legal meaning that we looked at earlier. And it is then up to the person that owns the birds in this scenario to accept that offer or not. So in this particular scenario, the defendant fell into this category. They were not offering the birds for sale. They were simply asking people to make offers to purchase the birds, and they were therefore found not liable. It's a very narrow distinction, but it's an important one, as I say. This then is the main exception to that general rule. So again, the general rule is that adverts are not offers, but there are certain circumstances when they can actually amount to offers. And the very famous case of Carlisle and Kerbolic Smoke Ball Company illustrates that point fairly well. But there's numerous other examples that would fall into this exception also. So let's go through the facts of Carlisle, which you can see on the screen here. That is a photocopy of the original advert in the paper, or whether or not it was an advert. That's what we're about to look at back in the day. So there's a quick question here just before we move on to this one from Joe Kelly. How does intention to accept, if a tender is issued and a favourite is lined up for acceptance, can the other tenders take action? Deceit in that the tender issue had no intention of accepting such. I think your question there, Joe, is if a public body has entered into contract with the person that they've selected, how can the others take action against that? Well, the action that the others would be taking there might not necessarily be in the law of contract. If it's a public sector scenario, it could be an action against the public sector body for breaching the procurement regulations. So that's probably where they would find their claim. If you're tendering in the public sector, you have to follow a set of rules, the procurement regulations, depending on whether you're from Ireland or the UK, it's slightly different, but they do largely the same thing. And if you don't follow those rules, then you have a cause of action against you for not following the rules. So that's probably where that would go, Joe, if I've picked up your question there correctly. If I haven't, feel free to retype it. Looking then at this case of Carlisle and Carbolic Smokeball Co., again, very famous case. The smokeball company placed what they thought was an advert into the local paper. Again, that's it back there on the previous slide. As part of that advert, they promised to pay £100, which again, I actually put this into an inflation calculator not that long ago. It's about £12,000 in today's money. They promised to pay £100 to anyone who caught influenza after using their smoke ball correctly. So here is a medicinal smoke ball. If you use it correctly, we're guaranteeing that you'll not catch the cold. And if you do, we'll give you £100, which is £12,000 in today's money. So that's what the advert said in effect. The smokeball company stated in the advert that £1,000 had been placed in a bank account to honour any claims made against it. So what they were saying here is, not only are we making that promise, we have set money aside to pay out if that promise is ever broken. If you ever catch the flu, having taken our smokeball, medicinal smokeball correctly. That's an important part of the facts that we'll come back to. So this is when the breach then arose. Mrs. Carlisle used the smoke ball as prescribed. She took it for the full 2 weeks and she still caught the flu. Ergo, you can see the problem here. She made a claim against the smoke ball company for payment of the £100 and they refused to pay out. So looking over what I've been saying up until now, is there actually a contract here? You know, what I've said up until this point is that adverts in the paper are non-binding. They are invitations to treat, they are not offers. So Mohammed has asked a question there, is that promise binding? I'm going to revert back with another question, Mohammed. Do you think it's binding? What do you think? Is there a contract here? Is there an offer? Is there an acceptance? That's the first things you have to look at. So no, why are you saying no, Mohammed? Tressa Jones says she thinks it's binding. Give me one more view, one more opinion. There's 170 of you in the crowd there. Bound to be one more. Thomas thinks it's binding. Rachel thinks it's binding. It is binding. And for the reason that we're about to look at here, it's clearly defined offer, KW, that's made with certain intentions. Okay, we'll look at this and we'll break it down. What we have here is actually a very special type of offer. This isn't an invitation to treat. It was in an advert, it was in the paper, but the way it's worded, it's actually worded as a very special type of offer, which I'm about to look at. So what we have here is an offer for someone to perform a specified act. So what is the specified act here? What are they asking the person to do? They're promising to pay out money in return for what act? What specified act? To use their product, to take it for 2 weeks as prescribed. Again, very common sales type tactic. And they've asked them, the market, asked the world to perform that act. That's part one. The second part is the intention that goes behind it. Why is their intention here to form, or for that act to be binding, for that promise to be binding? What's the key piece in the factual matrix that shows the smokeball company intended that promise to be binding? What did they do in the background? Second bullet point there. They put aside money. To any reasonable person, why would they have put aside money if they didn't intend that money to be used, if they didn't intend that promise to pay out to be binding? Okay, it's clearly not just a sales pitch at this point. It's clearly got intention behind it because they had put money aside to back up any claims. So what we have born out of this is a two-part test. Number one, an offer which requires you to perform a specified act, which is made with the correct intention for it to be binding, can be an offer in its own right. And we call that a unilateral offer. Where was that offer then accepted? Again, you always need an offer and you always need acceptance to form a contract. We've only talked about the offer here. Where was it accepted? How did Mrs. Carlisle accept that offer? Using the ball, exactly. She performed the specified act, and that gave rise to the unilateral contract between them. Everything else we've been talking to up until this point is what we call a bilateral offer, where you simply make a promise and the other side has to accept it. This is a unilateral offer because it requires the performance of a specified act. And the performance of that act is all that needs to be done to accept it. Slightly different rules apply there. So again, you can see here that we have the offer, we have the acceptance, and that ultimately did give rise to your contract. You can think of a number of different examples there that might fall into that unilateral offer category. You know, when you see an advert, or you might call it an advert, when you see a notice up on the telephone pole asking you to go and find someone's dog in return for €100, and again, you go and you find the dog, that promise to give the €100 is probably going to be binding because you've carried out the specified act and there's a clear intention for it to be binding there. So hopefully that makes sense. It's a little bit more of a niche area, and you know, you would spend weeks talking about this if you were studying a full law course, but hopefully that gives you an idea as to what amounts to an offer and what merely amounts to an invitation to treat. Only an offer can give rise to a legally enforceable contract. So on the other side of that coin, we have acceptance, which is much more straightforward to an extent. And when you start to unpack some of the rules surrounding communication of acceptance, it does get a little bit more complicated, but from broad brush purposes, it is fairly straightforward. So to accept an offer, you have to give an unequivocal expression of your intention and your assent to the terms of an offer. Just like I said at the beginning, someone has made an offer with 5 different terms. £100, I'll give it to you next week, I want the iPhone, so on and so forth. Your acceptance has to perfectly match that offer. If it doesn't match it, if it's one term that's missing or changed or waived or whatever the case happens to be, it's no longer an acceptance at that point. It would probably be a counter offer. Just like if you come back with a different price, you know, you've qualified your bid, you've said, you know what, I'll accept the price, but I want something else. That's a qualification. You're not accepting it at that point. You're actually issuing a new offer. It's a piece of case law we don't have on the slides here, but I would encourage you to take a note of, is Hyde and Wrench. Hyde v. Wrench. And that is the case authority to say, if you don't fully accept terms of an offer, if you issue a counter offer, all previous offers are destroyed. So if I offer you £100 for your iPhone, you turn around and say, no, I want 120. The original offer that I made of 100 is off the table. You can no longer turn around and try to snap up that offer. And that's exactly what happened in this case, which I think is from roughly 1840, to do with the sale of a farm for £1,000 or so. And again, one individual offered to buy the farm off the other. A counter offer was made asking for more money, and then he tried to turn around and snap up the original offer when he rejected the higher amount. Again, just goes to show you, you need to be careful when trying to accept offers, because if you don't do that correctly, you can destroy the offer altogether and it will be off the table. Sort of going through these backwards, but it doesn't really matter what way you approach them. The final one is that the acceptance has to be made in response to an offer. So if you think of it like this, if party A is making an offer to party B, it's only party B that can accept it. Again, they have to ultimately be the party that is responding to it in response to the specific offer itself. That stops Joe Bloggs off the street trying to sweep in and snap up an offer that clearly wasn't addressed to them. I think there's obvious utility in that rule of law. Couple of questions just coming through here, and some are longer than others. I tell you what, just conscious of the time, folks, I'll jump back to those questions just at the end, just to make sure that we get through the content in time. So that takes us through agreement. We're now about to go on to look at intention and consideration. Again, we'll get through these relatively quickly because they are relatively straightforward, at least from a helicopter point of view anyway. So the first one is intention to create legal relations. Short answer is you have to have intention for the agreement to be binding. And there are two main types of scenario that arise here. There are commercial or business scenarios or agreements, or social and domestic agreements. And the presumption in those two scenarios is clearly different. If you're dealing with a commercial organization, if it is Joe Bloggs Limited, subcontracting with ABC Limited, again, you're in that corporate sort of commercial environment, then the presumption is that you have intention. It's a rebuttable presumption. You can turn around and prove that there was never intended to be a contract. But the starting point is there will be intention in that scenario. Businesses operate to make money, and they use contracts as their vehicle for doing that. That's the presumption. As I said, that presumption can be rebutted. It was rebutted in this case of Rose and Frank and Compton Brothers, both commercial organizations, both limited companies, to do with the sale of tissue paper. And they had written into their agreement that they did not intend it to be a formal contract. And they had a mutual pledge clause written into that where they said, you know, regardless of what happens here, we don't intend this to be binding. So what they did in that scenario, by their express words and conduct, was rebut the presumption. They were able to prove to the reasonable person that there was no intention here. So therefore, when one of the parties breached that contract, there was no liability on their part. But that's very rarely the case. You would never normally see that in a construction scenario, because generally speaking, that intention is always deemed to be there. The other scenario on the other side of that coin is a social and domestic arrangement. So the likes of, you know, you doing some housework around the house in return for your spouse doing the dishes or whatever the case happens to be. You know, because that's in a social and domestic context, you're not deemed to have the intention to enter into a legally enforceable contract, whereby if the dishes aren't done right, you can sue the other party, or if the grass isn't cut right, you can be sued. You see the utility in that also. So social and domestic agreements are treated in an entirely different way. There's a plethora of very interesting case law in that particular area to do with husbands and wives promising payments and disappearing off to South Africa and never returning again. Yeah, the law does get quite colorful in that particular area. But the point is quite simple. There is no intention, but it can be rebutted in certain circumstances. Consideration then, so again, this is the slightly more complicated of the two final parts we're looking at. To enter into a contract, something of value has to have exchanged. Put it another way, the law does not like enforcing promises where something in return has not been given for that promise. So if I promise to give you my iPhone and you're not giving me anything in return for it, the law doesn't like to enforce that type of promise. It's called a nudum pactum, or a naked promise, which you can probably deduce from the Latin there, nudum, obvious, pactum, making a pact with someone, a naked promise. And so the point is, in English law, they do not like enforcing promises that where you haven't given anything in return for it, in consideration of the promise itself. In terms of how the courts and the law looks in this area, the modern analysis looks at this definition from Dunlop and Selfridge, who cited a fairly famous legal textbook. The courts cited a fairly important legal textbook in that case, is what I'm trying to say. And it boils down to this, and it's very difficult to read, hence my little Macaulay Culkin there, that an act of forbearance, or the promise thereof, so promising to forbear something, is the price for which the promise of the other is bought, and the promise thus given is enforceable. That probably sounds like double Dutch, because it almost still does to me, and I've been reading it for over a decade at this point. But it boils down to this. If someone makes a promise, we call that person the promisor, the person making the promise. I'll sell you my car for £1,000. That's a promise, okay? And what we're looking at here is when that promise can be enforced contractually. When will that promise amount to a legally enforceable contract? Well, what we have to have, as we talked about previously, is acceptance. Okay, you can accept it, that's fine, offer acceptance, and we have that agreement in place. But unless you give something in return for that promise, the offer and the acceptance is not enough. Something has to be given the other way. And in this scenario, the forbearance is handing over the £1,000. That is the price for which the promise to sell, this one, is bought. And therefore, the promise which was originally given is enforceable. I think that's the best way I can describe that key definition of consideration from Dunlop and Selfridge. The law in this area, trust me, gets a lot more complicated when you start looking at people that are changing contractual agreements and the need for new consideration. It does get a little bit more complicated, but from broad brush purposes, you have to give something in order to enforce a promise. So that then takes us on to breach of contract and looking at contractual damages. And Joe Kelly has a point there which links directly into what I was saying there. And what if you part pay the £1,000? Again, that's one of the rules of consideration, and the part payment is not sufficient consideration. The law also looks at, whether or not the £1,000 was enough. And the short answer is the law doesn't care whether the £1,000 is enough. It could be for a Ferrari, and £1,000 is clearly too cheap. All the law cares about is sufficiency. Consideration has to be sufficient, but it need not be adequate. There's a lot of those little rules that go in this area, Joe and co, but we're not going to get into that in any more detail for the purposes of today anyway. So, breach of contract and damages then. Breach of contract is fairly straightforward. It is when you simply haven't followed one of the terms of the agreement. If you're required to pour concrete with a certain level of coverage and you haven't done that, that's a breach of an express term, and then you would be liable in damages to fix it. That's what we're looking at here. So the general rule with respect to contractual damages is this. It is to compensate the innocent party, not to punish them. Again, I'll let that sink in. The aim of contractual damages is compensatory in nature. It's designed to restore the innocent party to the position they would have been in had the contract been performed. So if you were going to make £1 million profit and the contract was taken off you illegitimately, you would have a claim for loss of profit, and you'd be claiming that £1 million to put you back into the position you would have been in had you been able to perform. Again, I had a dispute over loss of profit not that long ago, and that can and will happen from time to time, where the entirety of a subcontract package is taken off of a supplier and they sue the main contractor for the full amount of damages. It can and will happen. When it comes then to assessing damages, it's never as straightforward as, well, that particular case was. Sometimes it's not as straightforward as simply making a loss of profit claim and being able to prove with reference to your tender how much profit you would have made. Normally there's a bit more to it than that, and you would have to go through an analysis that looks something like this. So the first thing you would probably look at is whether or not the contract has an agreed damages clause. We've all probably seen them before in construction. Liquidated damages is a prime example of that. So the breach is not completing by the completion date, and there is an agreed level of damages for not complying with the contract on that front. £100 per day, £10,000 per hour, it's probably the most I've seen. But again, it does happen from time to time that you will have an agreed clause within your contract. If you have that, then use it. If you don't, however, have that agreed damages provision, which would probably apply for most other breaches of contract apart from not meeting the completion date, then you need to go through the remainder of this analysis. So the first thing you have to consider is your expectation interest or your reliance interest. And these are the two different ways from broad brush purposes to calculate your damages. The first one is by far and away the most common, where you claim what you expected to make on the project, or you claim based on what the expected outcome was meant to be. I was contracted to provide a foundation. I didn't get my foundation. I am therefore entitled to bring in others to do it for me and charge the original contractor any extra over I have suffered. The net amount that I've paid out is the same amount I would have paid out to the original. That's the expectation interest. The reliance interest is much less common. where you're simply claiming back your wasted costs. You would sometimes see that in a claim against a public sector body for wasted tendering costs and whatnot. But by far and away, the most lucrative way of claiming damages is the expectation. What was the loss of profit going to be, apart from your mere reliance costs, costs that you suffered in reliance of the contract that was breached? So assuming then that you're going for your expectation, we then go on and we look at what we call the limiting factors. And the first preliminary point I'll make about this is who must prove them, okay? Always bear in mind, if you're making a claim for anything in civil law, it is up to the party claiming it to prove it. That's what we call the burden of proof. He or she who asserts must prove. And that is up to the party bringing the claim to prove causation. They have to prove that because you took the work off of us, we suffered this loss of profit. It's up to them to prove that. They can't simply assert it and expect the other side to disprove it. It is up to them to prove it on the balance of probabilities. They also must prove that the loss they have suffered was not too remote, and that it was linked directly to the breach of contract and was within both parties' reasonable contemplation. We'll look at the case law on that particular one shortly. But again, it's up to the party proving it to demonstrate it on the balance of probabilities. Mitigation is the other way around. It's not up to the party proving the damages to prove that they fully mitigated them. It is up to the party defending the claim to prove that they didn't mitigate their losses. You can let that sink in. So the general rule of law is that you can only recover damages which are reasonably mitigated against, but it is up to the party defending the claim to prove that you didn't mitigate it, okay? You'll sometimes see very basic defenses raised that, you're not getting all of the money you seek because you haven't mitigated. That's not enough. It is up to the party making that claim to prove it on the balance of probabilities. So the burden of proof on that particular area is actually with the defending party, not the claiming party. And then lastly, you have limitation periods, which again would normally be raised as a defense, and if they are, you would deal with it as such, but that is making sure you have actually issued your claim within the correct time frame. We've talked a few times here about claims against public sector bodies in a public procurement scenario. Depending on what jurisdiction you're in, you normally only have 30 days to raise that challenge from the date you became aware of the infringement. Most other claims for damages under contract will either be 6 years from the breach or potentially 12 years if you enter into the contract via a slightly more sophisticated mechanism called a deed, which I say is a slightly more sophisticated way of entering into the agreement itself, but it doesn't really change the underlying agreement itself, just how you enter into it. So to expand upon those couple of points, in terms of causation, it's the domino effect. Did that breach cause that loss? What you will sometimes see with claims in construction, for loss and expense and disruption and prolongation and such, is the contractor will know that they have suffered a set amount of loss. The books show that they've lost 100 grand on this project, but they're not actually able to prove what caused it. They know they were delayed, they know COVID happened, they know that there was material shortages, and maybe a supplier let them down. All of these items cause the loss, but they can't actually put the money on each one. And that is a problem. That is what we call a global claim. And the courts don't really like global claims. They will accept them in certain circumstances. The courts acknowledge that construction is very difficult and sometimes it is impossible to separate things to that level, but you should always make the attempt to link cause and effect, proving that each breach caused a specific loss. And if you don't do that, you run the risk of your claim falling down completely. Remoteness then, which links into the piece of case law we'll see on the next slide. It's all about proving that the loss you've suffered was a direct result of that breach, or alternatively, that it was within the reasonable contemplation of both parties. So you can claim for some exceptional losses that are not direct, so consequential loss, as long as both parties had it within their contemplation at the time of contracting. Mitigation, we talked about already. It's up to the other party to prove that you did not take reasonable steps to mitigate. And if they can do that, then your claim will be reduced. You can only recover what should have been reasonably mitigated against. And then lastly, have you actually commenced your claim against the other party within the correct time frame? And we call that a limitation period. And that limitation period could be dictated by the contract itself, or it could perhaps be implied by the likes of the Limitation Act of 1980. So, final piece of case law, and just before we get on to discharge of the contract, and then we wrap up. We're about 5 minutes behind time. So if you are stuck for time, just stick with us for the next 5 minutes or so, and we'll be wrapping up. So point being, not all losses are recoverable because the law draws a line in the sand. And that line in the sand is dictated by these 2 bullet points. You can recover losses which arise in the ordinary course of things. Again, if you can prove that had you been able to perform your side of the bargain, you would have recovered that money, then you can claim it under the first bullet point. And we call that the first limb of the Hadley test, which is the piece of case law where this particular test comes from. The other limb of that test are other losses that are within the reasonable contemplation of both parties. So that could be some exceptionally lucrative contract that you're no longer able to perform because you're delayed on the other job. The only ability that you would have to claim that is if both parties knew about that job from the outset. Because it's exceptional, because it's not something that arises in the usual course of things, you would have to demonstrate that it was within the reasonable contemplation of both parties in order to recover it. Otherwise, your losses will be too remote to be recoverable. So that then takes us on to our final topic, which is discharge of a contract, which again, we'll get through in the next couple of minutes, so do stick with us. So we've talked about how contracts come into being, and we've talked about the innards of a contract to an extent, and we'll cover that more next week. And we've talked about what happens if you breach a contract. We're now talking about how the contract comes to an end. And in short, there are 4 different ways to do that. Some are more common than others, and we're about to explore each of those in a bit of detail. So by far and away, the most common way for a contract to end is for it to be performed. You signed up to buy the iPhone for £100. The iPhone was given across to you. That's the contract over. It has been performed at that point. And the law ultimately understands that agreeing to a contractual promise is a fairly significant thing. And the only way you can discharge the contract by performance is by entirely performing your end of the bargain. We have a case here, which is Cutter and Powell, 1796. Fairly ancient case at this point, but it was all to do with a sailor sailing back home to Liverpool, but unfortunately he died before he actually got to the end of the journey, and the wife was trying to recover in the salary he would have made had he landed in Liverpool. And the court said no. His end of the bargain was to get that boat back to Liverpool. He was the second mate, I think, and he didn't do that. Therefore, he didn't perform. Therefore, the contract is not discharged by performance because he's no longer around to do it. It's a fairly onerous part of the law, that, and for that reason, a number of qualifications and exceptions have arisen over the years. What happens if a party is prevented from performing? You know, if his end of the bargain was to get that boat into port by the 1st of June, but he was prevented in doing so because the captain wanted to stop off somewhere else, well, then you couldn't enforce that original promise. Again, something similar happens in construction contracts, but we normally have ways of dealing with that by giving extensions of time and allowing money for that. So if you prevent performance, the entire obligation rule, to an extent, goes out the window. And again, it depends on the type of the obligation as well, whether or not the courts will enforce it and being fully performed. What happens if you have substantially performed it? There's a plethora of different cases there that talk about what substantial is, but just know it's not as clear-cut as, you know, the binary rule, whether or not you perform in full or not. There is a little bit of leeway there, and it ultimately depends on the obligation and whether or not you've substantially performed it. So, penultimate slide then, discharge by agreement. I wrote one of these yesterday, the day before, which was a side agreement or a deed of variation to mutually terminate a contract. Think of it this way. Contracts come into existence by agreement. You can end them by agreement. If you no longer want to work with one another, you can sign up to a new contract which cancels the other one. All of the formalities we looked at previously, offer, acceptance, consideration, etc., have to be in place, but there's no reason why you cannot terminate a contract by mutual agreement. Or what happens in construction from time to time, you might have written into the contract itself, if one of these set events happen, it will terminate the agreement. For example, if one party goes insolvent, we agree that the contract will end. If one party fails to pay the amount due within 13 weeks, we agree that we can end the contract. And again, you're just ending it by operation of an original contract term. And then finally, onto my favorite type of method of discharging a contract is repudiatory breach. So this particular one will get contentious. And this is where a contract is terminated by one side failing to perform it substantially. By carrying out a breach of contract, which is so severe, it goes to the root of the contract. I've sued a number of subcontractors in the past. I've adjudicated against a number of contractors before that on the basis that they've abandoned the site. Abandoning the site for obvious reasons goes to the root of the contract. You can then do one of two things. You can decide to affirm the contract. So you're saying, you know what, you've abandoned the site, but I'm going to apply the contract anyway, and I'm going to apply liquidated damages. Or you can decide to accept their repudiatory breach. It's like typo in there too, bringing the contract to an end. And by accepting their repudiatory breach, you bring the contract to an end, and you would then sue them for repudiatory damages. And maybe to illustrate in that scenario, if a subcontractor leaves the site, they have repudiated the contract, you would then accept that repudiation. That brings the contract to an end. You still need to get their work done. So you bring in a replacement subcontractor, you end up paying them 100 grand more than you would have paid the original. You would then sue the original for that 100 grand as your repudiatory damages claim. And that's how that law works. It's a very contentious area. I've been through a number of adjudications that look at repudiatory breach. Subcontractors in the audience, don't abandon the site, because it will probably give rise to repudiatory breach, or at least be very careful in doing so, and don't do so without taking proper advice. So just over 5 minutes over time, my apologies. I do like to ramble on about my favorite area of law, but thank you all for sticking with it to the end. If you do have any questions, feel free to get in touch. There's my email address, and I will drop you a copy of the slides. And if you are interested in learning a bit more about the law over a 12-week period, we are running a course accredited by the ISE, the Institution of Civil Engineers, which starts this September. And the first 12 weeks of that, as I say, is all looking at the law of contract and the law of negligence as well. So there's my details. Do get in touch. What I'll maybe do now, Jess, is just go through the questions that I didn't manage to get to. So I think I get down to about here. So who have we got? Lochdarth, again, I think I'm pronouncing that name wrong, but hopefully it's close enough. Following Ronan's question from earlier, if agreed upon by both parties, are there legal bodies, legal organizations that could act as a third-party mediator to settle that he said, she said situation, or would it always be settled through the court? Very good question. The short answer is the courts will always encourage the parties to mediate. The courts will always encourage the parties to try to settle it between themselves. If you're talking about a case in the UK, when it comes to high court litigation or court litigation, solicitors have to follow a set of rules called the civil procedure rules. And one of those rules is that you have to try to mediate or use alternative dispute resolution to try to avoid going court. So absolutely, Ronan, or Luke, sorry, whatever your name is there, you would be encouraged to mediate if you can. There are lots of bodies that do that. If it's a construction specific dispute, you might look at the RICS or the ICE. They both have mediation panels. If it's more of a civil dispute, you would be looking at the likes of CEDAR, the Centre for Effective Dispute Resolution. They can all appoint properly qualified people to do that. Very much encourage people to go down the mediation route myself. How does an insurance-backed guarantee be issued in the event of a similar activity? Not sure what the question is there. Joe, is that linked to your letter of intent? They're perhaps looking for an insurance-backed guarantee just to make sure that you've got the right finances to be able to do the work, which is a separate thing. You know, making sure people have the financial capacity is slightly separate to signing up the contract itself. They could also look for the likes of parent company guarantees, collateral warranties, etc., bonds perhaps. KW, if ad doesn't state intention, would this be non-binding? That I think links back to our discussion of Carlisle from Carbolic Smoke Ball Company. If it's clear from the advert that there is no intention, then yes, it would not be binding. For that unilateral offer to be valid and binding, it has to be clear, it has to specify the act, and has to have the intention. If that intention is not there, then no offer, no contract. Neil Bradshaw, out of interest, how is the word using defined? Would Mrs. Carlisle have to prove she had followed the set of instructions to make the smoke? Yep, absolutely. Again, the onus would be on her, being the party trying to prove her claim, that she used it as prescribed. How she went about doing that, I'm not 100% sure, but the burden of proof was on her, of course. Joe Kelly, in relation to many of the older legal precedents, how can they be applied to modern day contracts where the legislation has been passed? Well, if legislation has been passed which changes the scenery in any way, Joe, then that precedent would no longer be valid. We call that, and the Latin phrase for that is stare decisis, which again, the law can be changed and no longer applies thereafter. So you're absolutely right that the precedent might be defunct effectively by legislation which comes after. It's covered that one. Is a deposit sufficient to enforce a contract? I think that was back when we were looking at consideration, and the short answer is probably not. Part consideration is not good consideration, and part payment of a debt does not suffice, so probably not, Dennis, but it might depend on the facts. Joe Kelly, you're going to have to take my email address, Joe Kelly. You've got good lot of questions here, and they're good questions too. What if the amount is less than the contractor had requested for the original foundation? Can there be a claim? So I think that example there was when we were looking at repudiation. So in that scenario, there probably wouldn't be a claim against the original contractor because they haven't suffered a loss. So if your contractor has walked off the site, you've brought in a replacement and they're actually doing it for cheaper than the original, you're actually making a gain there. So you wouldn't actually have a claim against the original, remembering that the point of damages is to compensate, not to punish. Links back to that Robinson and Harmon case. During COVID, when contracts were prevented from meeting their program, could they claim for payments during that period? So it depends on the form of contract. So the likes of the NEC, as a prime example, clause 60.119 of the NEC is a prevention clause, which sets out roughly what you're describing there. Clo, I think your name's Clo, Cough, perhaps. It sets out a test for what amounts to an act of prevention, and COVID for contracts entered into before January 2020 was probably triggering that under NEC, but there was nothing like that under JCT. And because there was nothing like that under JCT, the risk probably lay with the contractor in that case. For an act of prevention to open up the time frame for delivery, it has to be one of the parties preventing performance, not COVID, not a neutral third-party issue. In that case, it would lie with the contractor. How are contract addenda issued to modify the contract as treated by discharge? Joe Kelly, as I say, contracts can be discharged in the exact same format that they are actually entered into. So you would probably look to see how the contract was entered into at the beginning. If it was entered into as a deed, you would probably use a deed of variation to modify it. You would just do the exact same thing that you did to enter into the agreement, to change it and to perhaps vary it. And then the rest of them are not questions, they are thank yous. And thank you all very much for joining us. I do appreciate we're now nearly 15 minutes over, but thank you all very much. Maybe over to you, Jess, if you're still there.
Yes, just want to say a huge thanks to William, and also just to say as well, session 2 at the same time next Tuesday, lunchtime seminar, and that's focusing on construction industry specific matters. So hopefully everyone has already registered for that as well. There's still obviously spaces available. So no, thank you very much, and hope to see you next week.